Sorry. Just check for me there. Anybody? I think there's a case of State versus King. Do you have the citation? State versus King. Have you heard of that case?
Yes, I think at some point we did touch on it in the previous applications.
Yeah. Do you have it, Mr. Mnisi? State versus King.
Yes.
Can I have a copy of?
Relates to the SARS matter.
Yeah, that's it.
Very lengthy case.
No, I just want a sentence from it so that I can quote it if necessary. Yeah, I don't know. The time I was in Pretoria, I don't think there's any judge who never dealt with that case. Took about 15 years.
We will find it.
Okay, fine, no problem. Are we ready? Yes, Mr. Mshololo. Yeah.
Adv Mshololo. I've been contacted by Mr. Mgomezu to stand in for him.
Okay.
He might come before or during the proceeding. He's engaged in another court matter.
Okay. Mr. Ramsipedi, you're laughing. Yes, ma'am. But have you told accused number 1 that you are standing in for you?
Yes, I spoke.
Okay, fine. Yes, ma'am.
Thank you, my lord. My lord, yesterday we paused at paragraph 1.7 of the heads of the state, wherein I wanted to check the record for the period of the 1st of August 2023, page 11. My lord, I'm now in possession of the record
Yes.
that has been referred to in this paragraph. My lord will see that from paragraph 1.7 of the state's heads of argument, it says, in question asked in clarification by the court, his role as an analyst became clear when it remarked that because, like he says, when I understood him to say that the investigation is ongoing and giving him an analyst some of the downloads, even Section 205, and he used the information to try and identify the persons. My lord, that is the reason I had to go back to the transcript record, and I was able to find or to locate, my lord, that actually what was explained into the record under the questions by court is reflected on page 11, line number 10. This is the answer. These are the remarks by His Lordship, my lord, that are being quoted here. On line number 10, page 11, for the transcript of the 1st of August 2023. The court remarked as follows, my lord. Your colleague who was here, did she tell you about the evidence which was led by this witness in your absence? If you want to read that evidence from the record, we can give you that time. Because like he says, when I understood him to say that the investigation is ongoing and giving him as an analyst some of the downloads, even the Section 205, and he used that information to try and identify the persons who are associated with the numbers, which they found from the downloads. And the response, my lord, by Colonel Steyn was that that is correct. In other words, he's correcting the submissions made by the court.
The court doesn't make submissions.
My lord, the clarification, because it was questions put on clarity.
I see.
Then he already clarified that it was a result of the downloads, my lord. My emphasis is that, my lord, there is no need to call Colonel Steyn because he had already confirmed that what he used is because he found the information from the downloads. Even the section 205, and he used that information to try and identify the persons who are associated with those numbers. He has explained himself, my lord, to say he used both.
But what he didn't say is that he used a program called Excel, which Mrs. Tallingham says that's what was used in order to get those, as Mr. Minister calls them,
My lord, if
materially incorrect numbers.
incorrect numbers.
Yeah.
My lord, it is my respectful submission that if that is the case, Colonel Steyn at the time when he was testifying, he knew he had that information, my lord.
No, he didn't say it. Even if he knew it, he didn't say it.
He didn't say it, but that information, that part of portion of evidence was available to the state at that particular
Okay,
time.
fine. That's another
Well-
another issue. That's fine. Okay.
When he was testifying, my lord.
Okay.
Yes, and he did not mention that when he was given that opportunity.
Okay.
And the state was also, my lord, given time to re-examine in order to clarify any other issues. And that was never done by the state to clarify that portion of evidence, my lord.
Okay.
And therefore, my lord, it is my submission that therefore the witness cannot be recalled to come and correct or to come and bring evidence which was available at the time when he was testifying. Thank you, my lord.
Okay.
And then I'll move on, my lord, to paragraph 1.8. And then we'll go to the same transcript of the 1st of August 2023, page 6. The state says, my lord, or submits as follows in paragraph 1.8. It is respectfully submitted that the state ought to be allowed to recall Colonel Steyn to clarify the issues of the two calls, to clarify whether the source of information of the two calls is cell phone downloads or section 205. I have already referred the court to this clarity which had already been given by Colonel Steyn, and the information that appears on pages 26 and 27 of his affidavit. My lord, if we go on page 6, line number 16. Line number 16, my lord, under Mr. Steyn, it says, that is correct, but also I can also mention, after I've received the information from Brigadier Gininda, I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downloads. Link here, you can see on one of the pages here on the screen. In other words, my lord, my submission is that what the state is asking has already been done. Steyn had already given this explanation, which is reflected on page 6 of the transcript record. That I threw it into the AMB notebook database, and then the linkages come with the section 205 and the cell phone downloads. Like here, you see on the one of the pages here on the screen, I think he was displaying it for us at that particular time. Therefore, the state cannot be given a second time now to come and repeat the same evidence which has been clarified on the record, my lord. Going further, my lord, on paragraph 1.9, in re-examination by the state, I won't read everything, my lord, but I'll just go to where I want to put emphasis and put it to the attention of the court. It's under my cross-examination. Also, my lord, it's under the examination by the state. In re-examination by the state on the 1st of August, page 14, my lord, we are on the same transcripts, page 14 to page 15. This was examination by the state. It's on line number 6. By Mr. Baloyi. You were asked by Advocate Mshololo as to how you established that the number which ends with 202, the complete number is 0733059202, made contact with the number belonging to Ms. Kelly Kumalo. You testified that you used the information derived from the investigating team as well as your own searches. It's coming from the words of the state that you have testified that you used information derived from the investigating team as well as your own searches. Can you just clarify the court as to what those searches entail? In other words, my lord, the witness, Kenneth Stein, had already been referred to by the state in respect of the true transactions that we are dealing with, and Kenneth Stein had already responded, my lord. Mr. Stein responded and said, I took the SAPS, I mean section 205. I can show that to the court. This is the way we receive it from the service provider. And we throw all this information in a central database. This is the response, my lord, from Kenneth Stein. And then on my AMB notebook program, I can go for a search, then I put it in the number which I received from the investigation team. I can put it in any number, then the program will pick up the number and point it out to me. That's the explanation which has been given, already been given by the same witness, my lord, the state intends to give. And then going down, my lord, to paragraph 1.13 of the state submissions, it also says an explanation by Lieutenant Kenneth Stein might foreclose the request of accused number 3. Oh, no, sorry, not that one, my lord. But I'm on paragraph 1.12. This is not about the evidence being favorable to the state or the evidence or the defense, but about the truth being determined in order for the court to arrive at a just decision on the case. The evidence is on record. It's clear, my lord, the explanation on the nature of the two transactions in dispute before this court, in which the state seeks clarity, has already been given in many respects, my lord, but I decided to quote this few and to refer this court to this few that has already been explained by Kenneth Stein. So what more does the state want Kenneth Stein to come and say? Because he has already clarified, especially on page 14, the paragraph I've just read, as to how he analyzed. He said, I took the SAPS, I mean section 205, I can show that court. This is the way we receive it from the service provider. She's saying that I took section 205, which I received from the service provider, and threw all information in a central database. My lord, I cannot repeat it again because it's on record. It's evidence that is on record, my lord. Moving further down, my lord, on paragraph 1.15, recording of a witness is a rule of practice to ensure that justice is done. It is neither the re-examination of a witness as provided for by Section 166 of Criminal Procedure Act 51. It is more based on Section 173 of the Constitution, the recalling, my lord. And then when I look at the provisions, my lord, of Section 173 of the Constitution, which I will quickly go through it with the leave of the court, my lord. Section 173 refers to inherent powers, and it reads as follows, my Lord. The Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each has inherent powers to protect and regulate their own process and to develop the common law taking into account the interest of justice. My submission, my Lord, is that looking at the interest of justice, the interest of justice, my Lord, I submit with due respect, does not allow the recalling of a witness to come and repeat evidence, explanation that has already been testified in court. Because that will amount to an unfair trial on the part of the defense case. The next page, my Lord, after page 3, which is page 4, and it says, my Lord, so the interest of justice is a prime consideration in deciding whether a witness should be recalled or not. This power is already vested in Section 167 of the Criminal Procedure Act. I've already addressed on the purpose of section of the provisions of Section 164 yesterday, that it's only invoked at the state of the court, not at the instance of the state. The interest of justice, my Lord, I submit, does not allow the recalling of a witness to come and repeat himself, to come and repeat evidence that is already there on the record. The only reason the state now wants to recall this witness is because of the contradiction which has been raised during the cross-examination of other witnesses. And therefore, my Lord, the interest of justice does not allow the recalling of the witness to come and clarify contradictions which arose during the cross-examination. I submit, my Lord. And further, my Lord, on the same paragraph, if I can just read it complete, which states that the court may at any stage of the criminal proceedings examine any person other than the accused and may recall and re-examine any person already examined at the proceeding, and shall examine or recall and re-examine the person if the evidence appears to the court to be essential to the just decision of the case. The witness cannot be called to come and lead evidence. The evidence that the state intends to lead now is irrelevant, my Lord. I submit with due respect. It's a repetition of the evidence which is already on the record. And then further to that, my Lord, also, I would like to make few submissions, my Lord, in the leading case. Of R versus Hepworth, my Lord, 1928 AD 265 at 277, on the issue of the interest of justice. My Lord, I'm referring on paragraph at 277. That's why I'm saying it's a leading case. It's a well-known case in this court, my Lord. But it is all more important in view of the exhortation of fairness. I quote, my Lord, what has been referred to by Lewis J.A. in this case, when he says, a criminal trial is not a game where one side is entitled to claim the benefits of any commission or mistake made by the other side. And a judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. That's where my emphasis is, my Lord, that I want to submit before this court. That, my Lord, justice will be done if the state is allowed to recall a witness in order to rectify the contradiction which has been created during cross-examination. It further says, my Lord, the judge's remarks not only apply in consideration of this section, but are particularly opposite to it. How the dual role of a person who decides and at the same time administrators of justice is fulfilled calls for sound judicial discernment. On one hand, the court searches for the facts, but on the other hand, a perceptibly even-handed trial is the goal. How far a court will go to repair the carelessness of a party in a matter of sound common sense in each case. Close quote, my Lord. My Lord, my submission is that what the state is intending to do here, as I have raised yesterday, my Lord, to say initially the state indicated that Steyn was no longer available. The state wants to close the gap. The state wants to close the lacuna on the evidence of cell phone records which has been presented before this court. My Lord, an injustice has already occurred wherein Lieutenant Colonel Gous was called to bring new evidence when the trial had already started. When the state realized that there was more information of which Colonel Steyn was still supposed to bring to this court, the state indicated that Colonel Steyn was no longer available. However, he is now available. It raises doubt, my Lord, whether Colonel Steyn was not available from the beginning. And now, my Lord, the same Colonel Steyn is called to come and repeat what I have submitted before this court. The explanation, the clarity the state that is seeking has already been given, my Lord. Therefore, it is my submission, therefore, that injustice will not be done if the application by the state is granted on those bases, my Lord. My Lord, also, I would like to refer this court to the transcript of the 17 April, of the proceedings for 17 April 2024. Page 37 and page 38 of this transcript or record, my Lord. Line number 18 to 25 on page 37. 17 April. The state here, my Lord, was page 37, line number 18, under Mr. Baloyi. I just want to refer you to the evidence of Colonel Steyn as appears on page 75 of the proceedings of 27 July 2023. Just to hear what your comment is, my colleague will just show you the relevant page. It will be page 75, line 6. It is the same page 23. Then my next point, during the analyst, I discovered that Ms. Kelly Kumalo, with a number which she gives, she received a call. This is coming from the state, my lord, that she received a call. And this is the clear evidence that Ms. Kelly Kumalo received a call from Ntulinkani with the number 073-305-902. And he goes on to say it belongs to Fisogutle. What is your comment regarding that number? So, my lord, in other words, the state has already placed this evidence. The state has already placed the nature of the calls. The state has already placed the nature of the transactions that took place between these two numbers, as it is being alleged by the state, my lord. And the response by Lieutenant Colonel Khosi says, thank you, my lord. The number is found under XDS, so some or other time accused 5 must have given the number out as reference on the credit. In other words, that's the response when the state invited the witness, Lieutenant Colonel Khosi, to comment on this call, on the nature of this call. And further, my lord, the submissions that were made by the state on the same page 38 under Mr. Baloyi, then he continues on page 76, proceedings of 27 July. If, my lord, if he says, then he continues on page 76, proceedings of 27 July 2023, line number 9, he is referring to the evidence of Colonel Steyn, that Colonel Steyn has already testified regarding this. It says that start date of the call was 2 August 2014, and the time was 22:40, and the duration of the call was 110 seconds, close to 2 minutes. She received a call from the other party, 073-305-90002. What is your comment on that? Lieutenant Colonel Steyn was referred to the evidence of Colonel Steyn regarding the same issue that the state is seeking to recall the witness to give clarity on. Going down, my lord, to line number 19 on the same page, also under Mr. Baloyi's. Then Colonel Steyn continues on page 77. So it means Colonel Steyn has testified on page 77, proceedings of 27 July, line number 8. From line 8, it says, in other words, she received a call, and the call was on 15 October, which is the second transaction, my lord, 15 October 2014 and 17:33:57. The time of the duration of the call was 98 seconds, a minute and a half more or less than the other party. It is 073-305-9202, which belongs to accused number 5. He says the tower reception area was 2G Ivory Farm, somewhere in Limpopo. What is your comment? The clarity has been sought regarding the evidence of Colonel Steyn, and the state has already placed on record the nature of these two transactions when that clarity was sought. And then further down, my lord, on page 39, line number 11, also under Mr. Baloyi, just finally he repeats the evidence on page 82 on the same, during the same time sitting on 27 July. In other words, he's referring to Steyn that he repeats the same information. From line 24, Mr. Steyn, page 82, July 2024, the second sentence from the bottom. Okay, thank you, my lord. The next entry is at 17:33:57. Received a call. It's clear. The answer is clear, my lord. He received a call from number 073-305-9202. Is the number of the suspect 5? And while he was still in the tower reception area, Ivory Park. What is your comment to that? So, my Lord, I can read into the record the reference which has already been made, the evidence which has already been placed before this court regarding the circumstances under which these two calls were made. And therefore, I submit, my Lord, that it is not in the interest of justice that the recalling of Colonel Steyn is granted, and it will amount to it will cause a prejudice to the side of the defense, and it will amount to an unfair trial on the side of the defense, especially of accused number 5. Those are my submissions, my Lord, as the court pleases.
Okay, thank you. Can you summarize for the accused the arguments by their counsels, Mr. Mnisi, Malo, and Ms. Mshololo?
lana okwabekwa abameli benu kuthiwa izabe sibekwe umshushisi zokuthi-ke kuphinde kubizwe uKenneth Steyn ukuthi eze la enkantolo njengoba umshushisi esefaka isicelo sokuthi akeze ukuthi azochaza ukuthi lokhu akubeke enkantolo bekuwukuthini ngoba khona okungathi akufani. Kuthiwa-ke lana konke lokho kungabekwa ngaphambi kwenkantolo ngesikhathi sokuthula izimpikiswano nezincomo, kusho ukuthi-ke yilokhu abakubiza ngokuthi ama-argument, ukuthi konke lokho kungakhulunywa ngesikhathi-ke sama-argument, ngoba lana kuthiwa-ke okwehlukayo ukuthi kukhona-ke la kuthiwa khona umsolo wesihlanu efonela inamba egcina ngo-358 okuthiwa ikaKelly Khumalo. Lapho kubonakala khona ukuthi kuthiwa umsolo wesihlanu noKelly Khumalo ibona-ke abo-mastermind noma ibona ababehongaphambili futhi nokuthi ibona abaletha laba abanye kuleli cala. Kuthiwa kupage 74 kwe-affidavit ka-Lieutenant Kenneth Steyn kuthiwa lapha inamba le kamsolwa wesihlanu yafonela uKelly Khumalo, kanti okunye kubonakala sengathi cha inamba ka-Arthur Mafokate eyafonela uKelly Khumalo futhi akuyena umsolwa wesihlanu. Manje-ke ngalokho-ke ukuthi akunasidingo sokuthi kuphindwe kubizwe uKenneth Steyn ukuthi azochaza ukuthi ngaphansi section 205 akatholanga ngokusemthethweni, futhi-ke uBrigadier Ginenda usafanele azochaza ukuthi kwenzeke kanjani ukuthi kube nezinto ezivela la enkantolo kuwukuthi azichazeki kahle ukuthi zihlangana kanjani. Ngizongena futhi lana kuloko kubekwe Mshololo ukuthi uthe lapha umshushisi uveze ukuthi ngaphansi ka-section 167 kuyabonakala ukuthi ufakazi usengabuyiswa futhi azolekelela inkantolo kokunye mhlambe nokuthi ijaji lingakwazi nalo ukuthi libize uKenneth Steyn. Kuthiwa-ke lokho bekuzolunga ukuba umshushisi wayengezwanga ukuthi abize lofaka, ukuthi umshushisi esembizile ufakazi aphinde futhi azomletha futhi. Manje la kuthiwa uKenneth Steyn kuthiwa-ke uKenneth Steyn lana uqala nje kwathiwa uKenneth Steyn akatholakali, yikho-ke kwenza ukuthi manje kuze kubizwe inkosi ukuthi eze kuzoba uyena oqhubekayo kodwa ke manje sekuthiwa uStein usiyatholakala manje kuthiwa amalungelo ngaphansi komthetho siseko athi uma kunobufakazi obusha ufakazi ubizelwe ukuzolu uma akunabufakazi obusha ufakazi lona obizwayo manje ubizelwe ukuzolungisa amaphutha akhe iphutha leli elokwehlukana kubufakazi bukaStein nokuba kwalethwa umama uVithilinga lapho ke umsolo wesihlanu kuthiwa washaya ucingo eshayela uKelly Khumalo kodwa ke umama uVithilinga mina mechazela uthi cha akukho lokho kubonakali kuyinto ekhona la kuma record ukuthi kwake kwenzeka okusho ukuthi akudingeki ukuthi ubize ubaba uStein ukuthi azophinda ubufakazi bakhe ngoba bese khulumile kuthiwa la uStein akazange asho ukuthi wasebenzisa iExcel okuchaza ukuthi manje uma engakushongo lokho usengabuyisa ukuthi azochaza ngoba le ndaba le Excel akazange ayibeke phambi kwenkantolo bese kuthi mase kuphendula kuthiwa no wayenalo ithuba lokuthi angakuveza lokho kodwa ke umshushisi akazange azame ukuthi amsize ukuthi akwazi ukuchaza kabanzi ukuthi kuzwakale lawo manje kusho ukuthi angeke alethwe futhi ukuthi azokhuluma into asayishilo ngoba kuthiwa yena wathatha bonke yonke ke le information ayithola le kwa Vodacom wayifaka kule ncwadi kuthiwa iMB notebook iprogram le kuthiwa ke and yase ke ikhipha and wathi ke angafaka nanoma yipi number khona lapho mifaka leyo number lapho iyakwazi ukuthi ikhiphe lokho abadinga ukuzwisisa ngaleyo number manje kuthiwa ubaba uStein konke lokho bese kuchazile and futhi ke akudingeki ukuthi angaphinde abuye futhi ngoba lokufakazi konke lokho sebuqoshiwe and futhi ke lo lwazi abaludingayo selukhona liqoshiwe phansi ubizwa ka futhi kukafakazi kuzobe kungasizi lutho bese ke kuthiwa ke indaba ka section 173 ikhomeka ukuthi ekutheni akusho ukuthi ufakazi kufanele ukuthi aphinde azosho lokho asekushilo injongo yobulungiswa ukuthi ayivumi ukuthi ufakazi azophinda kodwa ufanele eze uma ukuthi khona okusho inhloso yobulungiswa inhloso ke kamshushisi kuthiwa eyokuthi kubizwe lo fakazi lo ukuthi azothi abheke lamaphutha lawa ayenziwe lapha ukuthi amukulungiswa lamaphutha ngoba kuyabonakala ukuthi khona iphutha elikhona bese kubhekwa icala le-Adversus Hepworth lika 1929 lapho ekhuluma khona ngenjongo yokulungisa enkantolo chaziwe kabanzi ke lokho bese ke kuthiwa uKelly Khumalo khona call ayithola eyivela kungathi kuthiwa uNtuli kodwa ke kuthiwa lokho kufakazi sebabekwe enkantolo manje incazelo engalethwa eyacelwa siyatholakala kuyona incazelo futhi ezoba incazelo entsha usechazile ufakazi okusho ukuthi akusadingeki ukuthi aphinde alethwe enkantolo ukuthi azophinde achaze lokho asekuchazile bese court please.
Thank you. Yes, any re-examination, if any? Mr.
As the court pleases, my lord, the state just wishes to respond to one or two issues raised by my learned friends. My lord, all that my colleagues did was to take the state heads and then to criticize them. However, at the heart of the criticism of the state's argument, there's this golden thread, my lord, that they categorize the evidence of Ms. Vithilinga and Colonel Steyn regarding the two calls, as they put it, my lord, as a contradiction. We submit, my lord, that this demonstrates a fundamental misunderstanding, as we pointed out in our heads, of the nature of and we say this with the greatest of respect, this demonstrates the fundamental misunderstanding of the evidence of Ms. Fathilingam and Colonel Steyn. We submit, my lord, with the greatest of respect, that there's obfuscation of the role of Ms. Fathilingam as a forensic officer of a service provider of call data with the role of Lieutenant Colonel Steyn as an analyst. An analyst of an instrument, a cell phone, and accessing the downloads on the phone to which the service provider doesn't have access to these downloads. It's only Colonel Steyn as an analyst who's got access to these downloads and who can testify about it. Now, my lord, to then categorize the evidence of the two witnesses as a contradiction on this point, as we've argued, my lord, demonstrate a fundamental misunderstanding of their evidence. And Colonel Steyn is available, my lord, to clear up this misconception, to clear up this misunderstanding. And as we've submitted yesterday, my lord, it's in the interest of justice that he should be recalled to come and clarify this aspect so that we are all on the same page. And my lord, it is this fundamental misconception that has led to him being accused of fraud, of uttering, and it is this fundamental misconception, my lord, that has led to this personal attack on Colonel Steyn. And the state views this attack in a serious light, so much so that we had to drag him out of retirement, mindful of what Advocate Mshololo said. He's retired, my lord, but the allegations that have been leveled against him are so serious that they cannot be left unchallenged. And even if he's in retirement with all the old age ailments, we had to drag him out of retirement, my lord, to come and clarify these issues, because it's in the interest of justice, my lord, that they be clarified. We've been criticized, especially by Advocate Mnisi, that we should have dealt with these contradictions. But as we've just indicated, my lord, that viewed in the proper context, these are not contradictions. Each is testifying about the information that is applicable in their area of expertise. Lieutenant Colonel Steyn concluded his evidence on the 1st of August 2023, and Advocate Nisi was referring to Exhibit JJ1, the statement of Ms. Fathilingam, which clearly states that it was deposed to on the 16th of May 2024. So this, the evidence of Ms. Fathilingam came much later after the conclusion of the evidence of Colonel Steyn on the 1st of August 2023. Mr. Ngumalo argued that these are issues that can be addressed in argument, but we submit, my lord, that if there's such a fundamental misunderstanding of the evidence of the two witnesses, this is the issue that cannot be addressed during argument. We therefore submit, my lord, that the application ought to be granted. Advocate Mshololo argued that the state is asking the court to invoke Section 167. On the contrary, my lord, we have stated clearly in the heads that this is a rule of practice. We have, in the meantime, found that the case that the court was referring to of David King, case number 86/09, and judgment was delivered on the 8th of March 2010 by the Supreme Court of Appeal. And what the court said in this judgment is already contained in the heads of the state. On page 4, paragraph 5, the court said the following: there is no such thing as perfect justice, a system where an accused person should be shown every scintilla of information that might be useful to his defense, and discovery in criminal cases must always be a compromise. And this is the portion that we quoted in our heads. Fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's right should be subordinated to the public interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make it impracticable to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems. We submit, my lord, with the greatest of respect that this is an instance where the interest of justice trumps any other consideration. When Advocate Mshololo referred to the fact that the state is invoking, or is asking the court to invoke Section 167, we merely quoted Section 167 to indicate, my lord, that the application of the state is not an unusual occurrence. There's already provision for such a procedure in our law. We therefore, my lord, request that the application be granted.
Yeah, that's for my education, if there is a lack of it. Can legal representatives, meaning the state, can the state and also the defense invoke Section 167 or 186 and persuade the court or extol that persuasion to the court to say, the court is entitled or can invoke Section 167 or 186, not out of its own mero moto? Are you with me?
Yes, indeed, my lord.
Is it legal? Let's hear Mr. Ngomezulu first, or Mr. Miyeki first.
Yes. Yes.
Can litigants, represented litigants by the state and by the prosecutor and by the defense, implore a court to exercise its own?
I hear the court.
Oh, you've heard it?
I hear the
Thank you.
My lord, in all the cases that we researched yesterday after this application was made, actually they indicate that it is actually the court that can invoke that section to recall a witness that has not, to clarify any evidence or to clarify any issue that has arisen during the...
Yeah, I've heard you, but you see, you're investing the logic.
Yes.
I know it is, the Act
Yeah.
says I can do it.
Yes.
167
Yeah, but-
and 186. But can you,
It's
because you feel your client is being shortchanged.
In terms,
That's,
in terms
and then
of
this
the,
judge is so stupid, he doesn't see this point.
in
And you
terms
make
of
an
the-
application that, Judge, invoke section 167.
in terms
That's
of
what I'm
the-
asking.
In terms of the case law that is available, my lord,
Yes.
that is unknown. It has
Unknown,
not- yeah,
okay.
I have not come across case law that actually shows that the state or the defense can actually recall the witness to close the lacuna in the case.
Okay, Mr. Mnisi, sorry, Ramsepidi, you agree with your colleague?
As the court pleases, my lord. My lord, stricto sensu, it
Okay.
says, in the strictest terms of the Act, it says the court may recall a witness for clarification purposes, my lord. However, in answering the court's question, in the Shabir Sheikh matter, it was the defense
Yeah.
that recalled a witness for clarification, my lord.
Okay, fine, no, I'm aware of the case. Mr. Mnisi, educate me.
By convention, my lord, I think there is no impediment from one of the litigants to request the court, and the court can then use his discretion.
That's it. Happens every day, no? You're right. Yeah. Let's hear, unless Mr. Mngomalo and Mr. Mshololo say you are wrong.
No, I'm not saying it's wrong.
No, okay, fine, what do you say?
The court can use its own discretion on the application.
No, but you're not listening to Mr. Mnisi. Tell him what you said, Mr. Mted, tell him what you said. Repeat what you said. I don't think he understood you.
I understand.
Mr. Mngomalo, Mr. Mnisi, yeah. Just repeat what you said before, just before now. By convention, that's the... No. Once you have said it, he'll understand it. He didn't catch you. I but
I've said, my lord, by convention, there is no impediment on the part of the litigants to request the court or to make an application or to ask for an indulgence from the court to record a particular witness. And then the court in those instances can then exercise their own discretion.
Okay, fine. Mr. Ngumalo,
I'll fall in the same trap, my lord.
you follow?
I agree with my colleague.
Okay, all right.
Yes, I agree with my colleague fully.
Ms. Mshololo?
My lord, both these provisions, they are very clear.
Deba?
They are very clear
Okay.
to say the court may. It doesn't say any party during the proceedings.
No, you've missed the ball again.
Yes, my lord.
The court, the duty rests with the court.
Yes, my lord.
Now, the incantation by the defense, when they realize that they want the court to exercise its discretion in terms of 167 and 186, can they argue and persuade the court to utilize that discretion which rests on the court? That's the question.
My lord, can I make my submission?
Yes.
Okay. My lord, my first submission is that the section is clear. 167 says the court may. 186 says the court may. That's my submission, my lord.
We're fine.
These two provisions says the court may. It doesn't say any party. However, my lord, if it is at the instance of any of the parties, either between the state or by the defense, the court must use its discretion.
Okay, fine.
Yes, those are my submissions, my lord.
Okay, thank you.
No,
Yes,
the
Miss-
act, it's very clear to say it's the court, not by any party.
Okay, Mr.
Thank you, ma'am.
Baloi, any new wisdom?
As a court, please, I go along with the submissions of or counsel, I think we are all ad idiom that any party can request the court to invoke these provisions.
Okay, what's the time now?
It's 11:05.
Yeah, okay, let's come at 11:30.